Hello everybody, it's Monday the 5th of February 2018. Today I'm going to give details of the paperwork involved in the mass remedy process. The disclaimer is I'm not a lawyer, so you need to do your own research. So recently the High Court has been accepting these forms, apply for help with fees. It's also called an EX160, without requiring, not always, without always requiring your bank statements or proof of benefits. Okay, so if you're on benefits, this is straightforward. You just fill out up to section number 9, and then if you're on benefits, you go straight to 12. So you skip the 3rd page and you just go straight to the last page. It's very simple. All they want is your name and address and a signature and an email and phone. You don't have to give your phone and email, right? And the date signed. So if you've had your children stolen or your home stolen or your car stolen, you have to make a claim, an N1 claim. I don't have one to show you, but it's a 9-page document now, and it's all blue. You can type it up online, but to save it, it's a bit awkward. You have to export it. I can't remember how you export it, because if you save it as a PDF, it just gives you a blank, downloads a blank form off the internet. So you have to, I think you have to save it on your hard drive. I'll give you more details of that next time, because I need to check that out. Okay, so it is possible to save it as a PDF, export it and print it. So you need, of your claim form, this is the mass remedy claim form for the state terrorism of trafficking of humans and children and babies by the state. And so it's a corruption remedy demand. So because we've proved the corruption, we don't need to go to a hearing. We're just going the shortcut route and saying we just want this remedy. This is our remedy. So your claim for your remedy could be you want your children back, you want your home or your car back, or your benefits, benefit denial frauds, impoverishment frauds, and ruin frauds, where they just take everything away from you and leave you homeless because they've denied you your entitlement to your benefits. Which is a criminal offence. It is a corporate manslaughter, and it's treason, obviously, the violation of the oath to God to maintain God's laws, to serve and protect God's children. Okay, so I've done the help with the fees, EX160. I've done the N1 claim form, which is 9 pages, and on that you just say see attached, and you need to give your grounds for your claim, a little summary of what to just say. The template is already written out for you. The claim form template is already there, and so you just have to fill in the parties, the defendants, the people who've committed the criminal offences against you, right? So it's usually the police, the council, the courts, and it could be a foreign office or inland revenue or tax department, any other government department, right? You can just write the state. You can just put yourself versus the state if you really want to just make it simple. And then, so you have one for yourself, one copy for each of your defendants. Try not to have too many defendants. Just go to the most serious defendants. So it's usually a local authority and the state, the central government. And that includes your MP and your councillors and MEPs, because they're meant to sort this out so that we don't have to do this en masse. So the mass remedy process, a template, the form N1 is out there. It's on the previous talks and I'll put it up again. So after you've done your claim form, after you first go to the fees office, you get your help with the fees, the X160, you get your certificate. So your remission certificate, you get one of these. I'll show it from a distance. Okay, so it has a red seal on it. Okay, and so that then goes into when you do the filing. So the corruption claims are filed in the actions department. That's just around the corner to the fees office in the Strand in London in the UK. So that's that done. And then after you get your claim number, you fill out an application notice like this. That's an N244. And that's just a 2-page document. And on that one, you just say, you know, the remedy that demand, the draft order that you're seeking your remedy, that's attached to it. So you have to make an application for your remedy. You can do it by way of habeas corpus, right? But I believe a habeas corpus just produces the evidence inside the court. So if somebody's a political prisoner, like a child in care is a political prisoner, or in a mental health unit or a prison, hi Kay, yeah, I'm fine, hope you, okay, so you do the habeas corpus to produce the body of the evidence inside the court. But if say you've had a lot of terrorism, a lot of state terrorism against you, so once they take your children or they steal your property, you're a witness to state terrorism. And that is where they come out for you and they basically terrorize you on a daily basis like they do to me. So that is now proved that the councils are involved, the police are involved. It's called the Organised Criminal Network. They're the Protection Fraud Network. And they are everywhere in public services. They've infiltrated the public services and they're not allowing the public services to act honourably, because once you're a victim of state terrorism, you have to be protected under the Criminal Law Act, Section 4, 1967, that is, Section 4, that if you're a witness to crime, criminal offence, I'm going to talk about how they cover up these criminal offences, okay, by calling them taking their children into care. Now, they haven't taken your children into care. They have, they're child traffickers. They're using children as commodities to make money into their system. And some tax. And they take our flesh, blood, sweat and tear money from us, which they expect us to live on £73.10 a week, whilst these criminal corrupt officers are on hundreds of thousands of pounds a year, plus benefits and plus, you know, parties and conferences all day long as part of their jobs, you know. So we don't accept that our public servants are going to be living on more than us, right? We're divine children of God. Something's gone wrong, horribly wrong along the way, and we're demanding our equal share of prosperity on this planet, because God did not make this planet for corporate structures to make profits. Again, you know, using our blood, sweat and tears, mixing it with counterfeit currency. So, okay, so you've gone into do your own court hearing because you don't trust any solicitors. So you're actually entitled to make an application, an EX107, right? Which is, and if you're on fee exemption, or if you're on benefits, you can't afford the transcript of the court proceedings. So this is to request the transcription of court or tribunal proceedings, because if you're going to appeal to whatever's gone on because you don't understand legalese and you're not, you know, because you're a divine child of God, none of that makes any sense to you. Whatever the legislative laws are a fraud of the 1930 bankruptcy anyway. So you need, before you can appeal, you need the transcript and you need it on public expense. And this is on grounds of public interest in matters of great general public importance, on grounds that the solicitors and the barristers and the judges are conspiring to deny remedies. And it's not just the transcript of the judgment you want the transcript of the proceedings. You have to apply for that, and you have to demand that, because you say, well, how am I going to explain to another person what's gone on? They need to understand what's gone on. Okay, so they say Part 52 Civil Procedure Rules. So when it helps us, we'll use their laws, but when it doesn't help us, we won't, right? Paragraph 5.17 of the practice direction applies. So they want the case, the name of the judge, the date, whether you want the judgment only, the evidence only, or the entire proceedings. So I'd go for the entire proceedings because, you know, as I say, it's in the public interest, and they have to be transparent. Public hearings have to be made public anyway. So if you've asked for the entire proceeding, give reasons for your request. Have you obtained estimates? And all these transcribers, they charge different rates. So I've used Apple and I've used Merrill, and I preferred Apple because they were cheaper and they were really good. I mean, with Merrill, the tapes went missing a lot of the time. Well, they couldn't get hold of the tapes, right? So then, okay, so this mass remedy process, right? Wayne, data means human trafficking. Okay, so basically what we've got here are the grounds we give for fraudulent breaches of natural justice and human rights and overriding justice objective. So there's terrorism penalty warning against state officers and law officers. There's superior jurisdiction admission by the law courts. I mean, we're demanding that. We want, because there's corruption, because this remedy is being denied, so we want the law courts, to treat the corruption jurisdiction as higher than all other proceedings. So all you have to do to stop corrupt proceedings against you is to present the evidence of corruption, which means they're all conspiring together. The corporate structure is not an injured party. It's not allowed to bring claims against a human. And that in itself is evidence of corruption, right? And because we've proved mass corruption, because we've been denied remedies for decades now, because they've criminally covered up the crimes against babies and children and against witnesses and whistleblowers, right? We've proved that the state is unfit for purpose. The law courts, the judiciary are unfit for purpose, not because 100% of the time nobody got remedies of getting their children back. There are no cases of, you know, the council's doing the right thing when they've perjured in court, when they haven't produced any evidence of why they took the children in the first place, and it's all based on lies. So we talked about lies and how they get the corporate person who says, I've just come in, this is what the third person told me, this is what happened before I joined this case, and I'm only relying on what the other person has told me, and she's gone now, we don't know where she's gone, right? So they pretend that, you know, they are honest and they're telling the truth, and they're not. And they do this criminal cover-up of the crimes of trafficking, okay? So, okay, so the corruption remedy process, a superior conflict jurisdiction admission, inferior remedy only jurisdiction. So conflict means that because there's corruption, everyone's conspiring against you. So you can't, the lower courts have to stop whilst the high court, so these corruption claims that you're going to make for the mass remedies, this template that's been put out, you're saying that the remedies They can do the remedies in the lower courts as long as you get what you want, but they can't deny you remedy in the lower courts whilst this corruption investigation is going on in the higher court as part of your claim, or that you're being denied your remedy in the courts as part of your corruption claim. They can't then use the lower courts to punish you and torture you and try to discredit you with the mental health frauds and ruin frauds where you've got no money to even, you know, get the paper to write on and the pens to write on to submit your paperwork in the court to make your case, right? Admission by the law courts for the citizen, Crown and Parliament against the corporation, the state and the law courts. So, you know, so the citizen gets, the divine man, woman gets priority over the corporate structure. You can't have a corporate body win in court against a human being. That's impossible, because they can only serve and protect us. They can't fight us, and they can't be injured, and they can't claim from us. All these have to be reversed. All the fees that we paid for court fees, plus we've been denied remedy, that's all due back to us. You know, we can't be, this is state terrorism again in the courts, right? So conflict qualification fraud admission, superior jurisdiction protection breach contempt admission by the appeal court. So this is when you go to appeal for the citizen, Crown and Parliament against the corporation, the law courts. So what that means is, if you've proved, so say they take your children one after the other, and then they ruin you they stop your benefits, and they've done this corruption, and there's already a conflict there because the same council is coming out, is persecuting you, torturing you, right? So that is fraud that they do to try to disable you, as well as it's corporate manslaughter, okay? Citizens, the Crown and Parliament managed a corruption remedy process. They needed to achieve total destruction of a protection fraud network. It sold market frauds to organised crime and provided protection frauds for corrupt officers who managed them. They used career blackmail against ordinary officers, and both true evidence and false evidence for paedophile exposure blackmail against key officers. The paedophile protection frauds needed total corruption of child care authorities. The remedy process got organised crime proof and then child case corruption proof. In April 2017, it got a criminal conspiracy proof set against top state officers and the law courts. The Crown and Lord Bishops used it to decide the corruption remedy conditions for the 2017 Parliament session agreement. They needed an election-free period to enable a long session for remedy management. The surprise general election got the election-free period and long session. Remedy management needed responsibility apportionment between mass remedies by Parliament and case remedies by the law courts. There were remedy cooperation tests of Justice Agency from general election day for 6 months. Corrupt officers managed test sabotage frauds. The result is that every test got criminal conspiracy proof that is remedy unfitness proof against the law courts. The remedy process passed into the mass remedy stage. Mass remedies needed fraud proof against trial judges and appeal judges, and then voluntary remedies using evidence voluntary disclosure, plus case dismissal consents, plus immediate releases, and public apologies, and mass publicity by state officers for citizens against the state and law courts. The most efficient way to manage it was to start the criminal cases, get mass publicity, and progress to family cases, use cases in which mass publicity is proportionate, and then decide proportionate publicity for other family cases. The criminal mass remedy start case was the framing trial fraud of a citizen. Top state officers and top judges had organised crime partnerships. One of them was a drug production partnership. It managed production in Sussex because the water is good for it. The top state officers and top judges needed an organised crime concealment fraud. It needed framing trial fraud against a citizen. It is criminal conspiracy proof against law court judges and the framing fraud appeal of the citizen in 2016. 4 police officers wanted immunity deals in exchange for framing fraud full disclosure. Top state officers and top judges needed an intimidation fraud to get repeat perjury from the 4 police officers. The top state officers and top judges used framing fraud trial 2017 for the intimidation fraud. I'll just skip through that because it goes on and on. Crown prosecutors were not drug production partners. They had service of framing fraud until the mass remedy stage. The Crown prosecutors asked for a charge change hearing, got it, and used it to get a hearing audio record of the trial judge, ignoring a no case admission by the Crown prosecutor and making a trial order. It got a trial audio record of a case dismissal application by the citizen that got a dismissal refusal and adjournment order. There was no significant publicity. The Crown prosecutors used other cases. So that, then there's another paragraph which I'm not going to read because that case is still going on. The remedy process needs mass remedy lead cases. The regulation breach title fraud plus impoverishment frauds that forced the 3-Peel Drive mortgage default has everything needed for service as a lead case for title fraud remedies and consequential damage remedies. So that was my fraud eviction and violent and assault and attempts on our lives. That was the 9th of January and on the 9th of this year and 9th of August last year. This is Britannia Building Society trading as cooperative bank. So if anybody else has had those kinds of terrorism by Clearway Services, as many of us have, and then if any of you have been subjected to the eviction frauds of the organised criminal Winston Leachman in Romford County Court, then we're gathering the cases here as part of this. All of this, the mass remedy stage is all to do with all the decisions that have ever been made in Romford County Court or in any other courts where this particular individual has been taking cash off people and then not attending the evictions and not attending their court hearings and keeping the money and then not answering his phone. So we want a justice perversion finding, fraud finding, conspiracy finding, contempt remedy entitlement finding, remedy priority finding for the citizen against all defendants. And in my case, all orders, invalidity, declaration, revocation order, eviction warrant revocation, contempt liability order, plus special and general aggravated and exemplary damages order, jury trial assessment order, interim damage, immediate payment order, indemnity costs order, invalid records declaration, all records use publication prohibition order, immediate full disclosure order for the citizen against all defendants, contempt trial directions, hearing order. Okay, so that's that. So those are the kinds of crimes that we're being subjected to that we need to put on our appeal. Either it's an appeal if they don't give you your claim, and then, or you know, this goes in your claim that whatever the remedies that you seek. So yeah, that's it for today. Nothing, Catherine, you know your stuff, mainly educating us too. Yeah, I just want to say to everybody, don't go into defense mode. All right, they want you to go into defense mode because they tell you lies, that you done this, you done that, and you didn't, and then you start saying, oh, I didn't do that, I didn't do that. So don't do that. Just, if they make lies, just forget that, and then you just tell the truth about what crimes they've committed. Okay, So try to, and because you can dismiss everything that they say, because the lawyers are not, they're not involved, they're not witnesses. I mean, they're just giving these witness statements, but they're not an injured party. Neither is a counsel an injured party. So all you've got to show is the injuries caused to you, the loss and damage and injury caused to you, and harm caused to you or your family. And then you just go, if you see, because they don't understand human emotions, like, you know, I miss my children, you just have to say, you know, you got my children and it's worth £1,000 a day. They will understand that. If they have to pay for it, they will understand that. I mean, I'm not saying that, you know, a child's one day is worth unlimited amounts, whereas millions, okay? But I'm just saying that unless you are adamant about making a claim for an amount, an ongoing amount, so, you know, whatever they've done to this point, and you said if they don't return your children within 7 days, you're going to charge them £1,000 per day per child after 7 days. You see, what they do is they steal your child, and then they tell lies while they've taken it, and then they wait for you to go into defense mode. So because they say, oh, we're taking your children into care. No, they haven't. So you go into an attack mode by using the Criminal Law Act, and you mention the crimes. So they haven't taken your children, right? They have committed genocide, right? And they've treason. It's a treason because they had to perjure in their witness statements. They have to commit fraud. They have to commit a lot of criminal offences to do anything against you. So that's dishonourable, that's criminal. So you have to make sure that all the allegations you make are of a criminal nature. And corruption claims can be dealt with in the High Court. You don't have to lay an information in the Magistrates Court or or Crown Court, so you don't have to go through that process like they do with the CPS do with their criminal prosecutions. We do it as a corruption claim in the High Court, the fee exemption, fee remission certificate, then an application for your mass remedies, and you use those grounds, some of those grounds, which is that the judiciary is unfit for purpose, it's in remedy denial, and we're demanding remedies now because the mass remedy stage has been reached because we've been denied remedies for so long. Okay, until next time then, bye.